Well, welcome everyone to this first of three seminars on customs and trade under the TCA. Timothy, Lyons and I started talking about doing some seminars on trade about 6 months ago. And little did we realize that trade would become not just interesting, which is the case for all of us who are working in this area, but exciting, sexy, and my goodness, political at the same time. And so what we thought we would do is to talk a little bit about the various aspects of the TCA. And today is going to be focused on different forms of trading relationship with the EU. We're going to look specifically at goods. We're going to look at dispute resolution. And we are then also going to look at services, sometimes thought of as a Cinderella provision in the TCA. But we have the privilege of having Sam Lowe here, who's going to tell us just how exciting services can and will be. Timothy Lyons is going to join us in a moment. There are just some technical issues to get his camera and microphone on, and he will be talking about goods. Emilija Leinarte, my wonderful colleague from Cambridge, will be talking about dispute resolution. And my name is Catherine Barnard, and I'm Professor of EU Law at the University of Cambridge, and I'm also Deputy Director of UK Interchanging Europe, which is co-sponsoring and co-organising this event. Now, I'm not going to talk at length by way of introduction. What I've been tasked to do is to try to place all of what we're going to be talking about today and in the next couple of seminars into the broader context of how the TCA fits together. If you just give me one moment while I get my screen up for sharing. Timothy, can I just check you can see my slides?
I can, Catherine.
Okay, that's great. Thank you.
I'm now in the virtual world of the living. So.
Thank you very much indeed. So, as I said, I'm going to be talking just a little bit by way of introduction. And what I would like to do is just to start by thinking about the pyramid of trading relations. And specifically, we know that you've got the possibility of trading on WTO terms. There's free trade agreements, customs union, single market, economic and monetary union, and political union. Now, traditionally, the higher you go up the pyramid, the more integration there is. And just for those of you who are not familiar with this terminology, I just want to briefly introduce it to you. As you can see, WTO terms at the bottom, and with WTO terms, what we know is that states can trade between, sell goods between one another. They can levy tariffs, but any tariffs they levy must be on MFN terms. In other words, they must be non-discriminatory. Now, tariffs are an important source of revenue, but they also, of course, add significantly to cost. And therefore, in free trade agreements, that's when state A and B come together and they agree often that there should be zero tariffs on most goods and possibly zero quotas as well. They're sometimes called zero-zero agreements. So the great advantage about free trade agreements is, of course, that tariffs are removed. The disadvantage is the paperwork that comes with those tariffs, because only goods which can prove to originate in one of the member states can benefit from that zero tariff. And that in itself is quite difficult. There are very complicated rules on rules of origin. And of course, a large quantity of paperwork, now primarily online, which has got to be completed to prove the origin of goods. So moving up the pyramid in a customs union, the states A, B, and C come together and they decide that there's going to be no tariffs on goods moving between those states, but in order to try and reduce friction at the borders between states A, B, and C, goods coming in from a third country, state X, will have to pay a tariff if one is due, and that tariff will be the same whether the goods from state X enter via state A, B, or C. That tariff is set centrally, which of course means that states A, B, and C are no longer free to enter into their own trade deals, because otherwise that would undermine the basic premise of a customs union. Now, one of my bugbears, and certainly the bugbears of anyone who teaches in this area, is that people always seem to think about trade solely in terms of tariffs. And in fact, it's non-tariff barriers which are a far bigger problem, as those who've been trading between the UK and the EU have discovered. Now, in a single market, non-tariff barriers are removed as well in respect of goods, unless they can be justified or there is a harmonized standard. And then often in a single market, particularly in the EU single market, you also have the other freedoms, free movement of persons, free movement of services, and free movement of capital. Moving up one stage further, there's single currency and ultimately political union like the United States of America, but those for our purposes are much less relevant for today. Now, as you know, the higher up the pyramid you go, the greater the integration, the greater the economic benefits, the less friction there is on goods moving from state A to state B. But of course, that comes at a price, and that price is national sovereignty. Now, these, although I've presented it in a pyramid form, and these suggest, the pyramid suggests that these different levels are sequential and indeed mutually exclusive, that's not entirely correct. Because of course, if you've got a free trade agreement, it might not cover all sorts of areas, and therefore, if it doesn't cover, for example, the movement of people, then you fall back onto the WTO to see what the WTO says in that area. The other point to note is that often the WTO terms form the basis of what's agreed under the free trade agreement, and what you see is a bit of WTO plus in order to, if you have this free trade agreement. Now, the UK has done something rather unusual because it has moved down the pyramid. It was in the single market and of course has left the single market and the customs union, as Boris Johnson pledged, and it now has a free trade agreement with the EU in the form of the Trade and Cooperation Agreement. Now, the other point I just wanted to make is, of course, the position of Northern Ireland. And Northern Ireland is in a unique situation because, astonishingly, it spans, arguably, at least these three levels, and possibly this one as well, depending on how you look at it. It's in the single market for goods. It's in the EU customs union, although that's well hidden. And of course, it is also part of the UK single market, and it will benefit from any trade deal that the UK decides to do. So what we have here is quite a useful graphic, just to remind you that even within Europe, there are a number of different levels of integration. The ones I just want to draw your attention to, which of course you're familiar with, is the grey line here. That, of course, is all of the countries in the single market, which includes the EEA states, Norway, Iceland, and Liechtenstein. You've also got a free trade agreement going on here between the EFTA states. You've also got the customs union, where, which of course includes the EU 27, but added in Turkey, but not the EEA EFTA states, which is why there is a hard border between, for example, Norway and Sweden. And I would add to that, of course, the UK has now left these arrangements and is in a free trade agreement with the EU. But one of the intriguing things that we've learnt in the last few days is Emmanuel Macron, new French president, has said we need to think in more creative ways about having different types of relationship. It's not just a customs union and a single market, which is pretty deep integration, or a free trade agreement, which is pretty light integration. We need to think more creatively, and one possibility is to have some sort of European political community, which might ultimately welcome Ukraine and the United Kingdom, although you didn't mention the UK by name. So there are different ways of states cooperating with each other, different pros and cons of each one. As you know, the UK has left the single market and has gone for a fairly deep of the kind free trade agreement. And the free trade agreement broadly looks like this. I describe it a bit like a ham sandwich. That's the bread, top and bottom. And then this is the filling in the middle. With the filling in the middle, the most important part is the free trade agreement, which includes goods, which we're going to hear about from Timothy in a moment, services from Sam, and also these common dispute settlement understanding provisions, which Emilija is going to talk about. Final point, and then I will stop, just to remember that the TCA, certainly the provisions on goods, are very much reflective of the WTO rules on goods. Indeed, if you look at the chapter names broadly reflect the WTO agreements concerning goods. This is completely different from the situation under the Northern Ireland Protocol, which of course is in the withdrawal agreement. And the Northern Ireland Protocol still keeps Northern Ireland in the customs union, the EU customs union. It doesn't say expressly on the tin that that's the case, but if you spot the terminology, the reference to Regulation 952/2013 for Lowe, that is the European Customs Union that Northern Ireland is in. It's in the single market for goods, those 300 or so bits of legislation which bind Northern Ireland and will continue binding as and when they get updated. And also there is a significant role for the EU institutions, well, at least there is, until the UK government decides to tear the whole thing up. So that's what I want to say by way of introduction. I'm going to stop sharing my screen now. Timothy, are you there?
Indeed, I am.
And I am just going to, Timothy, if you just want to introduce yourself, and I will just get up your slides.
And while Catherine's kindly doing that for me, thank you very much, everybody, for logging in, particularly those of you who are in non-European time zones. We're immensely grateful that you should be looking at this in the middle of the night, and we hope you find it worthwhile. I think it's true to say that all of us on the panel have found that trade law now is an area that's absolutely fundamental to a lot of what we do, and has a lot of connections, of course, with what we had in the past with EU law, which we can still practice. But trade law is something of great importance. While Catherine is finding my
they're just coming.
Oh, well, isn't that brilliant? Thank you so much. You'll see that actually what I want to do is to make 4 simple points. The first is that I want to talk about the stability of the goods regime. Then I want to have a little look at the rights of traders in this regime relating to goods and customs and so on. Then thirdly, we'll have a little look at what the trade cooperation agreement does and doesn't cover, because some people, I'm sure you would have had this with your clients too, some people suddenly thought that they could move goods between the UK and the EU on the basis of the fact we had a free trade agreement, and there was nirvana for everybody. and it's simply not true. So what the TCA does and doesn't cover. And then finally, fourthly, I thought I'd say something quite specific about repairs of goods, because there are some interesting comparisons between what the EU TCA does and what other UK agreements do. So let's move to the next slide and look then at the stability of the goods regime. And I should say at the outset that I haven't decided to look at this simply as some sort of reaction to the latest headlines in the FT or whatever. I mean, clearly there are immense political problems about the TCA. That's why the third webinar in this series is going to be looking at what might happen in the future, what might be renegotiated or negotiated. But my focus really is, what does the agreement say? And what I think about the stability of the goods regime derives from the particular provisions in it, rather than the politics around it. In the UK, many of you will have been familiar with the fact that people who wanted Brexit said that the European Union was a kind of hotel from which you could never check out. And if you carry on that analogy, the TCA seems to me to suggest that it's a hotel into which people never really wanted to check in, because there are numerous ways of diminishing one's commitments under it and escaping from its obligations. And I particularly want to draw your attention to Article 411, which is headed up rebalancing, and its early provisions start to talk about how you might react to particular substantial difficulties which people need to address. But later on in the article, and if you look particularly at paragraphs 4 and 7, you'll see that there can be 4 yearly reviews on request, and that those reviews can lead in certain circumstances to the termination of heading 1. Then, if you look at Article 53, you can see that drawback provisions and inward processing relief provisions reviewed after 2 years. And so that's what we have in goods. Then we have over the top of that a 5-yearly review, and we have termination provisions as well. One of the things that I think comes out of this is, as I say on the slide, are your contracts TCA proof? If they're going to be lasting for a long time, make sure that your clients can react to whatever may happen in the review, the rebalancing, whatever. You need, in other words, whatever you're doing with goods, you need highly flexible contracts. And for example, if we were to be only a year away from a review, either a 4-year review or a 5-year review, or possibility of a review, then actually you might want to take that into account in the way that you draft your contract. What you don't want to do is suddenly find that you've got a business with a contract as its foundation, and that is being rendered unattractive in some way by virtue of reviews and what follows on from them. So point 1, this is, in my view, a somewhat an intentionally unstable regime, and it has enormous implications if you want to have stable contracts, and you should take that into account in drafting contracts. Now let's move on to the second point I want to make, which is about traders' rights. And Article 5.1 tells us that we've simply got rights between the parties. That's to say, between the states in international law. And you know perfectly well that we have a dualist regime in the United Kingdom. What happens in the international law space doesn't necessarily percolate through to the domestic space. And in that, we're very different from, say, a country like Brazil, where you can simply rely on WTO agreements in any court at any time, as it's part of your law. To deal with that issue, we've got, as you know, the 2020 Act, and particularly Section 29. Well, I'm not going to read Section 29 to you on the webinar. You probably read it yourself in any event, but it starts off by telling us that existing domestic law, which is defined, is modified. And it's modified in such a way that, to use the words of Lord Justice Green recently in a case involving Heathrow Airport and the Treasury, following Section 29, domestic law on an issue means what the TCA says. That isn't absolutely right, because what the TCA says is you don't have any rights. But actually, you know what he means, that the TCA is brought in to domestic law. Now, that, I think, is going to be terribly important in customs and trade matters particularly. I've had recent cases involving quotas, for example, and duty, where the fact that the trader gets rights is terribly important. And this notion of rights, I just say this before we leave it, you'll find that some people talk about this as the direct effect of the TCA. It's not direct effect. It's true that you end up as a trader with rights, but you end up with rights because of domestic law. And as I've already mentioned to you, it's existing domestic law as defined, which is modified. But you end up then with at least these provisions of the TCA being legally significant. And perhaps if we move on to the third slide, we can just remind ourselves why. And that's because the TCA creates a free trade agreement consistent with GATT. It introduces the national treatment article of GATT, transit, valuation, and so forth. And as Catherine has already said, they're the international elements of the multilateral trading system. It's worth saying, I think, that the whole of this TCA is intended to push the United Kingdom into reliance on its multilateral international treaties. And of course, you would expect to see these provisions of GATT relied on, but actually that's part of a bigger policy picture, not just in respect of goods, but in respect of other things as well. The United Kingdom has decided that it feels comfortable with multilateral international treaties. Now, if it's the case that we have got a free trade agreement and we're not going to have any duty on goods, what exactly does that mean? And we can find out a little bit about that by going to the definition of customs duty tucked away in Article 512B. The definitions in this agreement seem to me to be spread like confetti all over the place. And I don't know about you, but I really rather wish we had one definitions section. Well, we don't. But what we do learn from this definition of customs duty is that various things are excluded from it. That's to say, internal tax, which is levied consistently with GATT, things like anti-dumping duty, countervailing duty, safeguards duty, and so on, and also fees for services. So what we end up with is something that looks as if it's going to be quite exciting, but actually, if we start to remember import VAT, if we start to remember excise duty, if we start to remember even income tax, then actually there are many areas of taxation that you have to take account of. And you may think income tax is very odd there. But all I'll say is that quite recently I had a case in which a very high value item was being brought into the United Kingdom. What mattered in that circumstance was whether there was an impact on the non-dom regime and remittances from abroad into the United Kingdom for those purposes. So what the TCA does and does not cover, customs duty as defined, and then there's a whole raft of things that it does not cover. So that's the third point I was going to make. Now, the fourth point, let me say something quite specifically about the relief for repairs, the relief from duty where goods have been repaired. Now, we're all told, and it's right, that free trade agreements apply, of course, to goods of the other party. And therefore you have rules of origin and so on and so forth. Article 24 applies to goods regardless of their origin, and in that respect it's quite an important article. And it does give this relief for goods which move across the border, which are intended to be repaired. It's quite helpful, I think, to look at what repair means in these circumstances. It's specifically defined in Article 17H. And if you go there, you'll find that what is excluded is improvements and upgrades. Now that can be quite significant because repairs and improvements and upgrades are all very much on a continuum. So if you look at the UK-Japan article, for example, a similar article, but it refers to repair or alteration and doesn't have the exclusion. So actually, it looks to me as if there is a slightly more wriggle room if you're dealing with Japan in this article than in respect of the European Union. So we've already said, be sure that your contracts are TCA proof. I think you also need to be quite sure that your contracts are specifically engineered and drafted for the particular country with which you're dealing. If you're a business that has been used to dealing with non-EU countries and you've got established contractual relations, don't simply think you can switch your non-EU contracts into dealings with the EU countries. You can't do that. You have to look at it in a much more individual way. So now, finally then, of course, we've already seen that your contracts have to be bespoke. I've drawn attention to a contrast with the UK-Japan treaty. Perhaps the most significant contrast is the fact that the TCA is to be reviewed every 5 years. Japan is to be reviewed every 10 years. Which do you think is the most stable relationship? And with that happy question, I can pass you back to Catherine, who will be able to introduce the next speaker.
Well, thank you very much indeed for that, Timothy. Absolutely fascinating. Just before I introduce the next speaker, can I remind you, if you've got questions, there's a Q&A box at the bottom. Please feel free to put any questions you have there. Also, remember, there are 2 more seminars in this series in the next 2 Wednesdays. Next time, we'll be looking at some of the detailed operation of the new trading relationship and the economic effects. And the third and final seminar will have Julian Braithwaite from the FCDO and Adam Marshall talking about the current state of play and what might happen in the future. So now I turn to Sam Lowe, very well known in this field. I first got to know him at Centre for European Reform, but he's now gone on to far greater things at Flint Global. And of course, he writes the most fantastic newsletter, which is Teaching Us All Trade, for those of us who didn't know much about it to start with. Sam, you're going to talk about services. The floor is yours.
Thank you very much. And I should start with a slight apology, which is that at some point you may hear or even see my 2-year-old daughter, because effectively I can't control her, and she might just appear at any moment. But thank you very much for inviting me to speak, and also to speak about services, which is often sort of feels a bit unloved in the general Brexit discussion. But I think there probably are some good reasons for that. But more generally, it's talked about as something that all countries want to prioritize, that all countries want to do more on services trade, but very few actually manage to achieve anything. And I think it's useful to start by considering why that is. And it is true that the liberalization of services trade, and particularly trade in regulated services, can be tricky. And I think there are probably some quite good reasons for that. The first being that, unlike goods trade, it is actually quite difficult to check at the border and intervene in the event that you suspect that a service being sold remotely from another country to one of your citizens is compliant with your rules. And in a sense, there is this liability mismatch in that if something were to go wrong with a service being provided remotely from another legal jurisdiction by a foreign provider, and for example, they ripped off your consumer or they gave bad advice, perhaps potentially, if you think about medical services, caused damage to a human, the person or business that had provided that service, which is far away, will have done the damage, but the political blowback for that damage having occurred will be felt domestically. It will be domestic politicians that suffer. It will be the domestic regulator that gets blamed. So this question of how do you hold foreign providers to account, how do you guarantee remedy, how do you resolve an issue if something goes wrong, is quite key to understanding why trade in regulated services is quite tricky to liberalize. And in the context of the EU's general approach to dealing with this problem, they largely land on saying, well, if you want to sell a regulated service to our citizens, you have to incorporate locally so that you are within our regulatory jurisdiction so that we can intervene if something goes wrong. And the general EU regime vis-a-vis, we're talking largely about foreign investors here or foreign companies, is actually quite permissive. But when it comes to selling services into the EU from outside, selling regulated services into the EU from outside remotely, it can be much more difficult to do. There are more restrictions, there are limitations on who you can sell to. In the context of financial services, you might be able to sell to professionals, but not to retail clients. And essentially, if your product can cause damage to consumers, or in the context of financial services, create macroprudential issues or cause financial instability, there are going to be constraints on your ability to sell from outside. And free trade agreements, as a result, quite generally don't do very much when it comes to services, in terms of there's lots of text, they say lots of things, but largely they are just countries committing to continue operating their regime vis-a-vis third countries into the future. So if you're selling into that country, you might have a bit more confidence that the conditions you are operating under will remain, but they don't offer much in the way of general liberalization. When it comes to actual liberalization of cross-border provision of regulated services, the only really good example we have since probably GATS is of the EU single market. And in order to facilitate this liberalization, to facilitate this trade in services, the European Union had to recreate the domestic regulatory, political and legal architecture at the supranational level. And yet people still bemoan the lack of liberalization on services within the EU because it only got so far. So yes, it's tricky. And with the EU, with the UK deciding it wanted to extricate itself from the European Union's single market to end free movement of people, there was actually very little space available to the UK to ensure the continued access of its services providers to the European market. And in the context of the Trade and Cooperation Agreement, we have a deal that some people say it doesn't cover services. That's not true at all. It has many provisions covering services, but it doesn't offer anything equivalent to what was available to the UK whilst an EU member, and what could have been available to the UK had it remained within the EU single market, potentially via the EEA-EFTA route. Rather, it reasserts the EU's position vis-a-vis third country and commits the EU to continue treating the UK on that basis, with a couple of exceptions. And there are some exceptions and examples of the EU going slightly further than it normally would with third countries. One of those being with cabotage vis-a-vis freight, in that it does include provisions allowing for UK freight providers to make 2 drop-offs within the European Union's territory. Now, this is not comparable to what was permitted when the UK was an EU member, in which hauliers could make unlimited drop-offs between member states and 3 within 7 days within a member state. But it is better than what the EU would normally agree to. But these examples are few and far between. And in terms of impact, we also have to take into account the end of freedom of movement, because from my perspective, one of the reasons that actually the impact of exiting the EU in respect to services has not been felt to the extent that some people perhaps thought it would be, at least in practice, is because of COVID and the fact that people haven't been moving around. It's now the case that for a person such as me, so I work for Flint, which is a professional services firm, if I'm going to provide services in person to a person on the continent, I need to think about whether I need a work permit or not. And despite the TCA including an EU-wide list of permitted activities, which largely amounts to, if you're going for a business meeting, it's fine, but if you're going to sell directly to a person or business, then you probably need a work permit. In reality, these are subject to member state reservations, and you have to look country by country. And this sort of leads me to my second point, which is that you have these EU-wide provisions within the context of the Trade and Cooperation Agreement, but in reality, services trade still has a very large member state component. And actually, whilst the TCA might suggest you might be able to do or not do something, before doing it, you have to check the individual regulatory regime of individual member states, which may be more permissive or less. With Austria being a good example of one that is not very permissive at all when it comes to temporary work. And I always sort of think, well, what's quite a good example of the impact of this, and it's one that does get discussed in the press sometimes, but the impact of this on touring musicians is quite fascinating, in that whereas before the UK left the European Union, the UK was probably the touring hub for Europe, in that we had a lot of the industry that actually organised the logistics and the delivery of big musical events across the continent. That's no longer really possible because of the combination of the restrictions on the ability of people to work within the European Union, and also the restrictions on the ability of hauliers to move equipment around the European Union. And there are some other issues to do with carnets and the like, which I'm sure Timothy has come up against over and over again. But there are some elements that post-Brexit have been slightly better than perhaps some people assumed, insofar as, if we look at data, the fact that an adequacy decision was granted by the European Union means that it's still possible for firms to transfer personal data to the United Kingdom and to store it on servers in the United Kingdom and process it here. And that has, at least for smaller industry businesses that perhaps weren't quite on top of all the paperwork and standard contractual clauses that they would otherwise have needed, has been helpful. And also in financial services, we're going back to the fact that member states do apply their own unique regimes in many instances. Many member states have been quite pragmatic when it comes to their approach to UK-based financial services providers, in that they may have required them in the first instance to set up a local subsidiary, but for a while, and they've started to crack down on this, and also the Commission has started to look at this and might introduce new rules that make it more difficult to do so, but for a while have been quite pragmatic in allowing quite a lot of activities to continue happening in London. But looking forward, I'll sort of conclude on this point because I think it is one that is relevant. My general assumption on services trade and trade in regulated services is that many people in many jurisdictions are breaking the rules at any given time, and without realizing they're doing so. I sort of think of this as accidental illegality. And I do think the one that is going to start to catch companies out, and if it isn't already, are the restrictions on moving staff around either within companies or to engage on activities on behalf of companies, in that I think that lots of people still think they are able to act as they did before. They have been performing over Zoom for the last year and a half, where in many industries there are no restrictions if we're thinking about advertising, marketing and consultancy for the most part. But the moment people start traveling again, it will only take one officious border guard to intervene and ask what you were doing there and question why you didn't have a work permit or not, to cause some quite significant problems for the person, but also the company that employs them. And I will leave it there.
Well, thank you very much indeed for that. And thanks for taking such a broad approach to the concept of services. And certainly your last remarks have really hit home for me, not least because I've started traveling again. And indeed, I have met your officious border guard at 4 o'clock in the morning at Warsaw Airport. And the question is, should you be traveling with a copy of the TCA in your back pocket? It would be a very large back pocket, because you need to have all of the annexes there to point out that you are actually operating legally, but it is actually really quite a difficult issue now. Finally, I want to turn to Emilija Leinarte, who is my wonderful colleague at Cambridge. And what she's going to talk about is dispute resolution. We've already heard from Timothy that the TCA does not have direct effect, certainly in the old money language of European Union law. But Emilija is going to talk a bit about what actually the remedies are under the TCA, which will become particularly relevant going forward. Emilija, the floor is yours.
Hello, everyone. I'm just showing my slide. So my aim is to give a brief overview of the general dispute settlement mechanism, which is stated in Part 6 of the TCA. These are horizontal provisions. And I will be highlighting some of the key features of this regime, which you can see on the left side of the screen, as well as an overview of the procedural steps and some of the carve-outs from these horizontal provisions. Now, it is a state-to-state dispute resolution. So to be more precise, it is EU-UK dispute resolution mechanism that is parties to the TCA. So this is an arbitration that is essentially different from domestic enforcement. There is no recourse for individuals to bring claims against under the TCA. Now, like it is typical of the EU new generation free trade agreements, the dispute settlement, these horizontal provisions of Part 6, they are modeled on the dispute settlement regime under the World Trade Organization. But there are some essential differences. Now, to start with, WTO is a mixed agreement, so both the EU and member states are parties to it, which means that a dispute can be brought both against the EU and individual member states, or jointly against them. this is not something that is typical in the practice, because usually the European Commission represents member states in WTO disputes, but it does happen that disputes are brought against individual member states as well. So this would not be possible under the TCA, because the TCA is an EU-only agreement. Member states are not parties to it, and therefore claims cannot be brought against individual member states. Now, perhaps relatedly to this EU-only nature of the TCA is also another feature of the TCA, is that there is no investor-to-state dispute settlement mechanism. Perhaps this is a political decision. The European Court of Justice has ruled that ISDS is not, ISDS, investor-to-state dispute settlement, is not an exclusive competence of the European Union. And perhaps in order to avoid the TCA being also signed by the member states, the ISDS was left out. Now, one other feature is that there is no appeals mechanism, something that we have under the WTO, but it is currently not operational in practice due to the blocking of the appointment of judges under the WTO. Now, another point of the Part 6 dispute settlement mechanism is that it is highly fragmented and is therefore very, very complex mechanism. So there is this main mechanism, Part 6, but there are also numerous exceptions and carve-outs from this general regime, and also exceptions to exceptions, that is areas where the horizontal provisions do not apply, or they apply in some variation. And related to this fragmentation is another feature, that there is a relatively high degree of unilateral countermeasures serving as remedies under the TCA, and I will give some examples in a moment. Now, two additional points, of course, WTO and TCA overlap in subject areas to some degree, especially, of course, trade matters. So in case a dispute would concern such overlapping areas, a party would be able to choose a forum, would be either bringing it under the WTO or TCA, but of course not under both dispute mechanisms. And also to note, there is no role for the Court of Justice of the European Union under the TCA. There is a role under the withdrawal agreement, but not under the TCA. So as I said, TCA Title 6, Part 6, the horizontal dispute settlement provisions are modeled on the WTO dispute settlement, and so the procedural steps are largely reflect the WTO framework. So we have consultations, the purpose of which is for the parties to come to a mutually agreed solution. If that is not achieved, of course, then a party can request the establishment of a tribunal. Now, there is a difference here, perhaps more theoretical than practical, is that under the TCA, the terms of reference for the tribunal is to decide on the conformity of a measure. This is not the power that is given to the panel under the WTO. The final decision is made by the dispute settlement body of the WTO, which are simply all WTO members. But DSB usually adopts panel findings. So in practice, this may not be such a big difference. It is just to reflect the intergovernmental nature of the WTO regime. Then we have interim report, which turns into ruling after parties have commented on it. And if some kind of breach is concluded, then we move to compliance stage. Compliance must be immediate. If that is not possible, it must be within reasonable period of time. If that is not conducted, a party can ask for temporary compensation. If that fails, countermeasures are available. So all of this reflects, of course, again, the WTO regime. Now, as I said, there are a lot of carve-outs from this general dispute settlement mechanism. If I have put most of them, though the list is not exhaustive, on the right side of the slide. So those are areas where the general mechanism doesn't apply. To give some examples, good regulatory practices are not subject to these general rules, general provisions of level playing field. And here is an example of an exception to an exception. So when it comes to the application of precautionary principle, for example, it is subject to the Part 6 dispute settlement. Special rules apply to level playing field provisions. And here, with respect to labor and social, environmental and climate provisions, there is a possibility of countermeasures. So again, this feature of the dispute settlement to have a large scope for the application of unilateral countermeasures. Another big exception is competition policy, but here, of course, we are not talking about the actual antitrust litigation. This is a question of domestic or EU law, but we are speaking about a level playing field with respect to competition rules. So here, the general dispute settlement provisions would not apply. And of course, a big area is subsidy control. So the dispute settlement would not apply with respect to individual subsidies and whether the recovery remedy has been applied correctly. And there is a special procedure for the application of unilateral remedial measures once again. So there is always this fallback on the countermeasures when an area is carved out from the general dispute settlement. Fisheries, another example, and Part 3, law enforcement and judicial cooperation. So to recap, it is modeled on the WTO regime. It is, though, highly fragmented, lots of deviations and carve-outs, and a high degree of unilateral countermeasures available. So I will leave it there. Thank you.
A huge thanks for that, Emilija. That was absolutely fascinating. It seems extraordinarily complicated, and you can see why the EU was particularly worried about all of these issues, which presumably why there's different dispute resolution mechanisms. Some are quick and dirty and some are longer and more drawn out, as you very helpfully said. Please may I encourage you to put any questions you have in the Q&A box. I realise it's the end of the afternoon and dinner might be tempting you, but we have a few minutes left for questions. But while I'm just waiting for you to put finger to keyboard, I wonder, just going back to Emilija, as you know, the first case that's been brought by the EU against the UK has not been brought under the TCA, but has been brought under the WTO. Do you have any thoughts why the EU went down that route as opposed to the TCA route?
I don't know, and I was always wondering what would be the choice of forum in these situations. I would understand that from the UK's perspective, WTO may be a more attractive forum, simply because they can bring against the individual member states. But what would be the other way around? I actually I do not know the reasons for that.
I have sort of ill-informed opinions on this, and it's not a very legal answer. in that there were certain member states that had been pushing the Commission to bring this case against the UK for a while, so particularly ones with an interest in renewable energy, because the case is around local content provisions in respect of renewable energy. There is a fear within some in the Commission that once you open the can of worms, which is that TCA dispute settlement, that it never ends. And Timothy referred to this earlier. The entire TCA as a sort of construct is very fragile. You pull one string and the whole thing can start falling away straight away. So there's a fear that, you know, whoever starts the gun on that, you have to really mean it, because it could lead to the whole thing going. So in a way, the WTO route kicks the can. It appeases the member states. It gets it going. It's slow. Doesn't call into question the TCA, and it's fine. But one of the other reasons, so that's one potential reason why it went that route. One of the other reasons is that, as far as I'm aware, the actual arbitration function of the TCA isn't ready yet. As in, I don't think the arbiters have been appointed. I could be wrong on that, but there wasn't last time I looked. So in terms of wanting to move quickly, if you had to do something now to appease the member states, perhaps that actually wasn't an option.
And just one point that is actually in the comment box, and I think that is a very important one, is that the EU has a deep and long-lasting experience in the WTO proceedings, and this is really true, which the UK doesn't have, simply because the European Commission has been representing UK for years in the WTO, right? So one reason could be that as well.
So you're
may I just add to that?
Mm.
I've had experience recently of the EU wanting to go down a WTO route rather than a bilateral route in another context. And I just wonder if at the back of the EU's mind is the notion that actually it can make more trouble for the UK and the WTO than it can necessarily bilaterally, because it can bring in all sorts of other countries as well, not least the United States. I don't know, it's speculation, but I have my suspicions.
So all of these reasons are tactical rather than necessarily legal. And I think that's already quite a striking point, although of course, in the UK's favour, as we know, the appellate body is dysfunctional. So even if the panel finds against the UK, then what? And the UK is not part of the alternative mechanism, is it? So you're stuck. There's a question from Anonymous who says, how are disputes issues in the carved out areas resolved? Political engagement. I realise that's actually a big question, Emilija. Do you want to just briefly perhaps pick a couple of areas and contrast them? So, and this is the complexity of the TCA dispute, because each time there's a carve out, or necessarily not a carve out, but some kind of deviation from the horizontal provisions, then each time there is some different mechanism. So to give an example, right, there are special rules for the settlement of disputes with respect to level playing field for labor and social standards, environment and climate, and other instruments. So here, for example, we would have a panel of experts which would be making a non-binding recommendation to the parties, and then also a possibility of countermeasures referred to as remedial in some cases, or other measures in case of significant divergences, right? In this case, it's called rebalancing measures. So in most cases, you have countermeasures as a remedy if there's a carve out from the dispute settlement. The way that it would be applied would differ in each situation. That's why it's a highly fragmented mechanism. Thank you. That's really helpful. And if there's sort of countermeasures that might be taken, what do you think the EU would do to the UK? Where might they spot the weakness? Well, I think generally, if countermeasures would be applied, then probably everybody would need a political solution to that, and that would probably need to be solved through the Partnership Council, I think, or specialized committees. I think that would be the. And we're talking tariffs here mainly. Sam, do you have any thoughts about where would you hit the UK hard with tariffs?
So I have previously, sort of as a bit of fun, to try to work this out. And my instinct was just to look initially at the list the US had created in the context of the fallout from Boeing Airbus, whereby you have a lot of Scotland represented, and you have specific manufacturers in certain areas. One of the issues the EU does have when it comes to punishing the UK is that one of our key industries in respect of exports to the UK is zero rated on an MFN basis, so whiskey, whereas the US was able to target that more effectively. And if we think about it in the context of the TCA, I'm largely assuming that we're talking about the withdrawal of preferences, of preferential treatment. It makes targeting whiskey a bit more difficult, but of course you still could target cars, some food products, and elsewhere. But if you're just approaching this tactically, you say, well, okay, where are there key industries in key constituencies? Where will we upset the most conservative MPs? I mean, it's not particularly legal. It's quite grubby, but that does tend to be how these things work. I always think about when I found out about the fact that the EU levied tariffs on US playing card exports in the context in the fallout of the Trump steel and aluminium tariffs, and the reason for that was there was a big US playing card manufacturer in Mitch McConnell's constituent. You know, this is how it goes.
I've always had, thank you, I didn't know about the playing card, but I always had that they would have sort of Scottish salmon in mind, relatively small, and yet will upset the Scots very much indeed, which of course will just add pressure to our already quite strained devolution settlement. One person writing into the Q&A, going back to the question about why the WTO route rather than the TCA route, makes the point that wind energy issues are faced by the EU and other parts of the world, especially in Asia. So there is broader interest in the WTO decision on that.
Although I've always wondered about the EU opening this discussion, because local content, giving preferential treatment to local providers in the context of renewable energy, I don't think it's going to take too long to find some examples of EU member states doing the exact same thing.
Yeah, absolutely. Listen, ladies and gentlemen, we've just gone past 6 o'clock. Just before we close, can I remind you of our session next week, where the issue that Sam's just alluded to, local content and rules of origin, that absolutely fascinating and tricky issues to be discussed. Emilija is going to come back and do another bravura performance on conformity assessments. Andrew Deakin from 39 Essex Chambers is going to talk about TBT and SPS. And Anna Jerzewska was going to talk about the practical problems at the border, of which we know there are many. Thank you very much indeed, all of you, for attending this seminar, to the speakers for their excellent insights, and to 39 Essex Chambers for kindly providing all of the technological backup. And I look forward to seeing as many of you as possible in a week's time. Thank you very much indeed, and goodbye.